Okay, so since subsidiary legislation can be abused, so we need to know the method of controlling the subsidiary legislation. So basically there are four methods of controlling. Okay, the first one is judicial control. Okay, what does it mean by judicial control? So whatever here, okay, remember this subsidiary legislation that has been approved, this sometimes it can sometimes the act itself is ultra vires of the original principal act. So what can they do is that basically they can apply for judicial review. This is what we call judicial control. So basically when you're using judicial review, you actually apply the doctrine of ultra vires, whereby a court may declare any regulation as void if it's made in excess of statutory authority. So let's say this minister, okay, when this minister has exceeded or his power or excessively abused his power, so basically you can apply to the High Court for a judicial review. So first control is the judicial control. So the court will actually look. The court will look whether the acts itself, the rules itself has not follow certain procedure prescribed the Parent Act. Okay, so or if it's substantively contrary to the constitution, so the court may exercise its power and to declare subsidiary legislation void if it's made under the ultra vires doctrine, or either one of the two grounds, which is substantive or procedural. So under judicial control, you can go to High Court, apply for judicial review. The court may declare void based on either substantive ultra vires or procedural ultra vires. So whether the contents itself is ultra vires or in violation of certain act, or in violation of the Parent Act, or in violation of the Federal Constitution, the court may declare is substantive ultra vires, or if it's not following any procedure, the court may declare it procedural ultra vires. You're going to learn later under the administrative law. Okay, the next method of controlling is consultation. Now, normally the Parent Act will require certain consultation. For example, if you want to develop a housing project in certain area, possibly you have to get a public consultation or some agency consultation. So if you fail to consult those as required, so chances are that the subsidiary legislation is void. So basically ministers should ensure that you have to follow whatever the procedure prescribed. So otherwise, that particular regulation cannot be effective. Okay, and then the other methods of controlling subsidiary legislation is through publication. Okay, so basically you may require publication. Okay, some statute may require or make it publication as mandatory. So if you don't actually publish it, okay, so the subsidiary legislation is void. Okay, so basically under section 19 subsection 1 of the Interpretation Act 1948 and 1967, subsidiary legislation commences on the date prescribed, or where there is no date prescribed, the date immediately following the date of its publication. So normally if it's gazetted today, the enforcement date may be later. But if there is no date being stated in that particular gazette, so the enforcement date will be the following date of its publication. So it follows, depends on what was stated. And then at federal level, subsidiary legislation, which is required to be published, okay, it may be published in either in Imlay and English, okay, and then normally basically published either in part Part A or Part B, what we call tambahan perundangan A or tambahan perundangan B. Let me just show you straight to you. Okay. Okay, look at here. Tambahan perundangan A, or what we call Legislature Supplement A, contains all proclamation, rules, regulation, orders, and bylaw. And tambahan perundangan B, Legislature Supplement B, which contain all other subsidiary legislation. So basically, these are more on the subsidiary legislation. So the subsidiary legislation is seriously numbered either with prefix PUA or PUB, depends, depending on the part of the gazette is published. So PU stands for Pemberitahuan Perundangan, A or PUB. So the the fourth one, which is the last method of controlling, which is what we call legislative control. So basically, an act, a parent act, or enabling statute may have provision which confer the rights of making law to be vested on executive. Okay, so Parent Act. Okay, and then however, Parliament has the power to revoke or vary those particular delegated legislation. So now the thing is, sometimes there might be debate. There might be debate in Parliament concerning certain issues. Okay, concerning certain issues, and the minister has to respond to all those issues. Yeah. Okay. Most of the time, the issues involve very sensitive issues. Mostly public issues. So if it's being raised in the Parliament, so the minister has to ask. So that's why sometimes the subsidiary legislation, which is made by the executive, so sometimes there are requirement that you should lay those subsidiary legislation before Dewan Rakyat or before Dewan Rakyat and Dewan Negara. So it all depends. Sometimes you don't have to lay before the Parliament. Sometimes you have to lay before the Parliament. So it depends on the what sort of acts, what sort of subsidiary legislation you're going to introduce. Okay, so laying procedure, there are few methods, either simple laying, negative resolution, or affirmative resolution laying procedures. So I suggest you look at the notes which I give you in detail. Okay, so that's all about sources of law, written law, and we have done everything on the topics of the sources of law. Please have a look at the notes given. Look also at the question which I'm going to give to you, which you need to discuss in the tutorials. Thank you very much.